I don't mean count to 3 like you're my child, and you can record all day long.
I know I can't.
Record all day long.
I know. And I'm asking you, why are you trying to...
Because those are the rules, that's why.
Because there's rules. Can I see that rule, please?
He wants the video. He told me he has to be there. He doesn't want to go back there.
Yeah.
So he's gonna
Do you have any reasonable, articulable suspicion that I committed a crime? Am I being detained?
Don't go in there. I have to escort you out because the rules are you're
What? And I asked you what rule?
Don't you respond to a respondent to
May I see the rule? Because it's not on my notice of appearance to the court. There's nothing about wearing red tags and going in rooms. If you cannot show me that, I'm not. Unlawful orders are not orders at all. Is it inconvenience for you not to abuse my rights? Is that what it is?
I didn't hear what he said.
Do you feel it's inconvenient for you to abuse my rights? Is that what it is? Can you please not walk so closely behind me, sir? Oh, I thought you said you wanted to show me something. Alrighty. I want to be difficult because I have rights. So you guys view rights as difficult.
All right, let's go.
Let's go where?
Is he supposed to be in here?
Let's go where?
Where's he supposed to be?
The respondent's room.
Sir, there you go.
No, thank you. Do you have any reasonable articulable suspicion that I committed a crime? Am I being?
You're supposed to see the respondent. You're a respondent right now.
Am I being detained?
Do you want to cooperate or you want to leave?
I'm asking for the rule.
Do you want to cooperate or do you want to leave?
By cooperate, do you mean cooperate with you
By
abusing my
going
rights?
into the room like you're supposed to, or,
Says who?
or we do.
Says you said so. So I'm going to go in this room because you said so.
Yes, sir.
Negative.
All right, then
Do you have any reasonable
you can
articulable
leave-
suspicion
you
that
can
I
leave then.
committed a crime?
You can leave then, okay?
Okay.
If you don't want to, you don't want to cooperate. You can leave.
Cooperate.
Yes, sir.
Cooperate with you guys abusing my rights?
We're-
Last time we met, this court unilaterally scheduled a CMC and added this motion the day before the hearing, and then heard this motion and failed to perform any of the duties of the CMC, as if there was no CMC at all. But still, nothing changed from last hearing, which is that this court may not hear this hearing until jurisdiction is gained, and I have to today still lack service. You can't have a lawsuit without process of service, and I've written a motion for clarification, so this court will rule on that first. Because this court has not ruled on that, all you're hearing is one-sided story, which is also unfair to me, and that's part of the reason why I filed a motion to disqualify you last week, which you also did not rule on that, which you were supposed to rule on that before you scheduled this hearing, but instead you went ahead, forged ahead with this hearing, and then of course denied my motion to disqualify you because it would have been pretty silly to recuse yourself after you went through all that trouble of writing those orders. Thank you, Your Honor. I would like to begin by reminding this court of its judicial oath to uphold and support the Constitution of the United States of America, as per Florida Statute 105.031, subsection 4B, and also remind this court of its judicial oath to support the Constitution of the United States and the state of Florida, as per Florida Statute 876.05, subsection 1. Furthermore, in making its ruling on respondent's recent motion to disqualify, this court has declared that it can and will be fair and unbiased, moving forward. I will accept that statement in good faith. The purpose of reconsideration is to remove the taint of prejudice where rulings might be perceived as tainted. I did make a record last week that during the hearing where the stay-away order was implemented, I actually had to defend myself on the hallway, on the floor of the hallway outside of your very courtroom. That is clearly not a fair trial. Florida rules of judicial administration provide that upon receipt of a motion to disqualify, the judge shall enter an order granting to disqualify, but the judge did not do so. He waited 5 months and made 3 other rulings. I will show the court today emails between myself and the JA in which the judge subsequently disqualified himself 2 hours after my email. Yeah, we're here today to reconsider and to vacate that order based upon poor administration of justice, based upon fraud upon the court, and those are 2 of the 4 reasons that you can reconsider any motion. I would also,
Right,
I would like to read to you.
You're not introducing evidence today for me to make a ruling. The whole purpose of today was legal argument why you think I should vacate that order, why I should reconsider it, vacate the order, and then give you a new hearing on that motion. Okay? So I don't know, you wouldn't need to introduce your 911 recording or anything like that today. Again, today's just the argument of why I should vacate that prior order.
And that's exactly why, because there's new evidence that wasn't at the original hearing. But anyhow, in North Shore Hospital, Inc. versus Baker, in the Florida Supreme Court, 1962, the Supreme Court reaffirmed the long-standing tenet that a trial court has the inherent authority to control its own interlocutory orders prior to final judgment. That means you may consider all motions at any time prior to final judgment. Further, in 1984, the 4th District attempted to clarify this apparent contradiction in Commercial Garden Mall versus Success Academy Incorporated, also in the Florida 4th District Court of Appeal, 1984. The court held that while non-final orders were not subject to a motion for rehearing, a trial judge nevertheless has the discretion to choose to entertain such a motion precisely because it has jurisdiction to control its non-final orders prior to entry of judgment. Therefore, you may look and even rehear any motion at any time. You have the standing to do so, which is why they didn't seek the stay away order during that date. That was just given to them because the judge already had me on the floor in the hallway. You shouldn't have. Indeed, you should not have heard anything beyond that. I mentioned this to you last week. Sua sponte, once you heard that I defended myself on the hallway floor outside of your courtroom, you should have already vacated this. This is already wasting precious resources of the court system to have us here today. There's two small children, 3-year-old and a 4-year-old, that haven't seen a father in 17 months. It's going to be 18 months.
And that what? Then you sat outside on the benches and...
That is incorrect.
Had the hearing on your Zoom?
That is incorrect.
What is...
If I may explain. Thank you. So I arrived approximately 1 p.m. for the 1:30 hearing, and I told them I'm here to appear for the 1:30 hearing. The sheriff said to me, there's nobody doing in-person hearings. So I broke out my notice and I said, right here, it's notice Zoom or room 11156. I'm pretty sure any prudent person, given the opportunity, the choice to appear in person or on Zoom, a prudent person would arrive in person. So I did so. And about 15 minutes passed, and we found the judicial assistant out in the hallway, and I showed her the notice. Look, I was noticed to appear in person here, so I'm here. Please let me in the courtroom. She went and talked to the judge, came back, and she said the judge is not letting anybody in the courtroom. So then I sent her back again. Can you please tell the judge, if he's not going to let me in the courtroom, which he noticed me to do, can he at least give me a 20 minutes continuance so I can go back to my office and defend myself in private? She disappeared. She came back. Now it's about 1:35, 1:30 something. And she said, the judge wanted me to tell you that he's already started the hearing without you now, and he's gonna give a default judgment against you if you do not appear in the next 5 minutes on Zoom. You may look at the record of that hearing, and you'll see before I arrived, he did say that to the court. Oh, Mr. Dean arrived in person. I'm going to square this away. I'm going to give him 5 minutes. What could I do if I'm knocking on the courtroom door, if I'm right outside of your door, and you give me 5 minutes? Where could I possibly go? Where could I possibly defend myself? How is that fair? In the duress that put me under, the immense duress, and you already know I'm a 100% service disabled veteran, to have me not on the bench, on the floor, with my stuff spread all over the floor that I can't find anything. And I had three physical copies of evidence to present. And now he says it's a Zoom hearing. So guess what? I went from all my evidence and exhibits in person to I can now have no exhibits because it's no longer in person. So my 3 physical copies are dead. So now I have no evidence. I'm on the floor. I'm panicking because people are walking by me. I'm under incredible duress. And There's no possible way that you can say that that's a fair trial. That's a fair hearing. It is clearly not.
On October 17th of 22.
Yes.
There's nothing that you need to show me. The order of recusal is on CMS. I have seen the order of recusal.
What she's
So
saying,
what else would you like to argue?
what she's saying is that he recused himself for some unknown reason, but it was not prejudicial treatment towards me. But if I can show you an email sent 2 hours before his recusal, 2 hours before his recusal, you'll see that he was saying, I want to see you guys in person. And I said, you're going to see me again in person so you can put me on the floor outside of your courthouse? Is that what you're going to do? And then he recused himself within an hour. That is not a fair trial. That is absolutely pertinent for you to make your ruling on this hearing. If you're not to see it, is again denying me my opportunity for a fair trial. Motion for reconsideration can be heard based upon fraud, but you're not even willing to look at the evidence of fraud. My motion for reconsideration is based upon fraud on this court, which this court would not allow me to show, and also based upon a clear, unadulterated, prejudicial, unfair trial. There's never been a more unfair trial in the 17th district than there was that day. I can guarantee you that no lawyer in the history of our country has ever had to defend anybody on the not a bench, as you tried to allude to. No. The floor of a hallway outside of the courtroom door with people walking by, and for Ms. Bonner to say, that's fair, that's absurd. That is misrepresenting her knowledge as a litigator. This court knows very well that that's not a fair trial. You, in fact, yourself told me last week, Your Honor, that if that was the case in your courtroom, that you would have not had me outside the court. You said you would have brought me inside the room, and you showed me the little TV that I would have been sat in front of. That is not what happened there. So clearly you do not see that as a fair trial. Please uphold your own word and grant my motion to vacate this motion for reconsideration. Thank you. I'm gonna move this court to disqualify the judge at this time. Your prejudicial treatment is noted.
Sir.
Well, I've made the verbal.
You're not muted. You can put it in writing as the law requires.
No, it does not
You can put the
require.
motion in writing.
It does not
Okay,
require that.
folks, I don't think we have any of the other stuff.
The motion,
set, so
I
if
can
we
make that
do-
motion in person, and as I've done, it's an oral motion.
Sir, I'm not allowing you to unmute yourself again. You have to put it in writing. You can file it, and I will rule on it. Okay? Thank you, folks. The hearing is over.
Oh, she called the police. Oh, you called the police. For what? Hey, what's up, guys? What's going on, fellas? Officer Vasquez, Officer Calvo, and Officer Ramirez. No, can we talk right here? I'm waiting on a car rental.
Do you want him trespassed or?
Want me trespassed?
Give me a second.
Do you know how trespassing works, sir?
Sir, how you
Do
doing?
you know that they have to ask you to leave before you can start that? You've already violated my rights, asking him if he wants me trespassed. Nobody's asked me to leave. You did. No, he did not. You asked him if he wants me trespassed. And that's what you asked. You said, do you want him trespassed?
Okay, let's calm down for a minute here.
Sure, I'm calm. I'm perfectly calm.
If they don't want to do business, man, they don't want to do business.
That's not how it works, but okay.
It's a private business.
I understand what it is. It's a franchise, but I understand what it is.
And if they don't want to do business, they don't have to do business.
Yeah, well, that's fair enough, but there's going to be recourse.
Okay, that's fine. That's not
Sure.
We can take it up with court.
Yeah, but you coming in here, John Wayneing it, ain't going to work. You just asked on film if you want him trespassed.
Right.
You didn't ask him, have you asked him to leave? Did he ask if they asked me to leave?
Oh, you're right.
No, you didn't ask that. So you just violated my rights right away. That was obnoxious to do that. So just say I'm sorry, and I'll just apologize.
My apologies.
Okay, fair enough. I'll accept that in good faith.
Could we go outside and talk calmly?
Sure, in good faith.
Thank you.
But not because I've been trespassed, not because I've been asked to leave. For the record, I've not been asked to leave. The only mention of it was when you asked me if I wanted to do trespass, and that's absolutely out of control. I accept your apology in good faith. I'll grab my stuff and we'll continue this conversation on film outside.
No problem. Thank you for cooperating.
No, my pleasure. I'm extremely distressed. This is unacceptable, and I have everything on film what's happened here. And there will be recourse, and calling the cops before asking me to leave is another issue we're going to deal with.
Mr. Dean, you're here for both parties?
Yes, ma'am.
And are you an attorney?
I am not.
So there's going to be an order today, if there wasn't already an order reflecting that you need to get counsel within 10 days, okay?
Well, we can't make any orders at this point. You don't have jurisdiction to even hear today's CMC nor the motion to strike. As I challenge jurisdiction.
I'll decide that, okay?
Right, but that does need to be decided. You needed to decide that before we came here today because I filed a motion for clarification. My stance is that this is an ambush tactics employed by this court. I was notified of this motion for this hearing yesterday afternoon, which would be 0 days notice, as opposed to the law rule 1.090 subsection D that requires 5 days minimum for service, which I'm certain this court knows that, and still this court unilaterally scheduled this motion, which is why I'll be filing a motion to disqualify this judge later this afternoon. But this court has failed to establish jurisdiction because I filed a motion for clarification on why the last judge was recused. She claims to be recused for sua sponte, but 2 years in, she recused herself 2 days after I filed a motion to disqualify her, thereby basically handcuffing me and saying she left by herself, so now I can't challenge her old rulings, which is unfair. Okay, have a good day. That was absolutely unacceptable, but we'll address it later. I thought you read the emails, and I articulated very clearly in those emails what you said.
I muted you, so you cannot interrupt me when I'm speaking. All right, I have a pretty docket,
respect must be mutual. You can't cut me off and then ask me not to cut you off. And I can go ahead and tell you we don't need to bother because I'm going to be filing another motion to disqualify you. So we can see justice is